I'm Nigel Howell. I'm work as Head of Investigation here at the Institute in the Professional Standards Office. We deal with complaints and disciplinary issues against members, firms and students, and all of those complaints would come through us. Today, particularly interested in personal debt issues and how the bylaws of the Institute impact and how that's relevant, which I'll talk about in a moment. The Institute's bylaws, and I don't want to bore you by quoting from them, but there's two areas. There's a Principal Bylaw 7, look them up on the website if you want to, and Disciplinary Bylaws 4, where these rules are set out. Basically, there are certain types of personal debt that automatically trigger a disciplinary issue, and we have no choice in that. And I'll explain on the different types of debt in a moment. The principal bylaw I mentioned, bylaw 7, is specific to bankruptcy, and it says that if you are made bankrupt, you automatically lose your institute membership. That means there's no investigation, there's no disciplinary hearings, it's automatic and non-negotiable, I'm afraid. IVAs are a disciplinary liability, but unlike the bankruptcy, they're unlikely to mean you lose your membership. Once you enter into a formal IVA arrangement, that is a disciplinary liability, and you should tell us. We will then contact the supervisor of the arrangement, we'll monitor it, and generally speaking, as long as you come out the other end of the arrangement successfully, you can continue as a member, and it will go to the investigation committee because, as I say, the bylaws dictate there is a liability to disciplinary action. But we tend to try and be pragmatic, and unless there are any aggravating features to it, once you come out the other end, you might face a small amount of costs, but that will be it, and you can carry on as a member. County court judgments are also specifically mentioned in the Disciplinary Bylaw 4. And they also automatically mean there is a liability to disciplinary action. Again, we try to be pragmatic. We understand times are hard, people do get in difficulties, and we don't want to be beating people with a stick, making their problems worse. However, the bylaws say if you don't satisfy a county court judgment, as a chartered accountant, you are liable to disciplinary action, and we would have to open a file on that. And the questions we'd be asking are why you haven't satisfied it. Are you going to satisfy it? Are you appealing against it? In the absence of an appeal or actually paying the debt, then you will end up with a disciplinary sanction. But again, because it's a financial issue, those sanctions are likely to be relatively low level, and again, in the absence of aggravating features, which I'll explain in a minute, won't be membership threatening. If in the difficulty you're in, you've been dishonest somewhere, you've misled somebody, it's not straightforward, that is something we term an aggravating feature, and that may escalate the sanction, potentially even if it's dishonesty, lead to losing your membership. Informal debt strategies is a slightly more grey area because when our disciplinary bylaws were written, they weren't really that common. So while I can be quite clear on a formal arrangement such as bankruptcy, IVA, CCJs, something informal is not specifically covered in the bylaws, and because we try to be pragmatic, I would say if it's informal and you're doing your best to come to an arrangement to settle your debts, you don't need to tell us, and it shouldn't lead to any disciplinary action. If you are made bankrupt and you've lost your membership, once you're discharged, there's no reason why you can't apply to get back into membership. If there are aggravating features to the bankruptcy, which I referred to, that makes it less likely you'll be let in, but there's no reason why you can't apply. I would say if you are in personal debt trouble, from a disciplinary point of view, we don't need to know about it until something formal happens, a court action, a CCJ, an IVA. Informal arrangements or where you're struggling, we don't formally need to be notified at that point. If I could give you advice, if you're struggling with debt, as I say, you don't have to notify us unless there's a formal arrangement. If that happens, I would suggest you do tell us, because you'll get credit for doing that. Otherwise, I would just generally say Carver are there, they're available, they'll help you, it's a confidential service. You should get in touch and seek their help. We've also got the Ethics Advisory Service as part of the Institute. They're also a confidential service you can talk to, let them know what your difficulties are. They'll give you some advice, they might refer you to Carver as well, but just ask for help before it gets too far. Carver, if you're in touch with them, it's completely confidential and there's no way we'll get to find out about it without you letting us know the situation.